Megan Ma is a distinguished figure operating in the intersection of law, AI, and technology generally. The co-director of Stanford's CodeX Center for Legal Informatics, she's explored these fields at Harvard, Cambridge, Sciences Po, McGill, as a legal futurist at Filevine, and presently at Stanford. In this interview, Megan navigates through the complex landscape of AI development, from its philosophical origins to its practical implications in both law and beyond. We will explore the ongoing debates between open versus closed source development, the implications of rapid technological advancement on legal systems, and the critical role of education in demystifying AI. Megan's perspective is particularly poignant at a time when the potential and risks of AI are critically balanced on the edge of global regulatory frameworks. So join us as we engage with Megan Ma on these pressing issues, how to conceive of and also how to define the bounds of artificial intelligence as it continues to evolve and reshape our world.
Okay, awesome. So, well, first off, Megan, thanks so much for taking the time. Super excited to have you here. I guess in some context about our project, so we mentioned that we met with the former president of Google Canada. He had more of a high-level understanding of AI and really gave our users kind of what are the trends, what's happening. And then next week, we're going to be meeting with the former CTO of NASA, who's going to dive into more of the technical stuff. But and we're really excited to have you to understand more about the law and everything behind that. So I think a really big thing with law plays a huge role in dictating the pace of development, is really how it feels. From the builder sides, builders are like, law, slow down, don't bring us too much regulation, don't slow us down. And then from the other civilian side, I think in general, there's a lot of fear and people are just banking on the law to really set the right guardrails to make sure, this development is happening in a good pace. So I guess to open up, it's can you shed some light on the how behind the law? How are those guardrails going to be set? And where is it today?
Yeah, that's a great question. Thank you again, Annabelle and Max, for inviting me on this.
Thank you for coming on.
Yeah, so I think you've got your finger right on the pulse behind what I think law theoretically should be doing, where you're trying to kind of find the right balance between not hindering innovation, but also ensuring that everyone is mitigated against risks, and how do you deal with governance in a broader sense. I think what's interesting is the fact that part of our center is exactly kind of the opposite. And what I mean by that is we think about technology as actually a solution to some of the existing pain points in the legal system. We think that at current state, the legal system is not perfect. There are lots of inefficiencies. 80% of people don't have access to lawyers. And so it seems interesting that kind of you look at it, people are thinking or returning to the legal system and turning to regulation for help when they can't get it. And so how do we actually appropriately leverage the tools that are being out there and all the emerging tech that is coming? What can we do with that technology for the legal system? But to your point about regulation, a lot of the work that we are looking into right now in terms of AI governance and risk mitigation actually focuses on technical interventions. And I think what's fascinating is that I always analogize this with similar emerging technology, or what was once an emerging technology, which is the autonomous vehicle. Everyone originally turned to regulators and were like, we need you to figure out what's going to go on with these robot cars or self-driving cars. And actually, for a time, I worked with the Ministry of Transportation in Ontario.
Oh, cool.
And I was on the working group for autonomous vehicles, and this was the big question. And one of the biggest concerns they have is, how do we actually retrofit our infrastructure? And I think in a similar light, people are asking, does the law in its current state, does regulation in its current state, can it accurately accommodate for the risks involved with generative AI? And the question is yes and no. And as every lawyer says, it depends. And the reason behind that is because, take for example, professional conduct. Everyone knows about the infamous New York Times case with the lawyer that had used ChatGPT, hallucinated a bunch of cases. Most recently, 2 more lawyers did that, as if, we don't learn from our past mistakes. And a lot of people were like, well, this is disrupting our professional and ethical conduct as a practice. But really, we went into a deep dive. We set up a task force with MIT, and we came up with a set of 7 principles. A lot of the lawyers were surprised that actually those 7 principles parallel the American Bar Association's model rules for professional conduct. They were like, how is this any different? And we said, yeah, it's no different. Why? It's about application. And so we decided to give them tangible examples of what is consistent with the ABA and what's inconsistent. And from there, the actual State Bar of California, they started to adopt actually the MIT Task Force principles. And so when it comes to retrofitting, it's about what is specific about this technology that we can then kind of reconcile with the rules that already are out there. The alternative side to it is, I've been thinking a lot about questions of terms of service agreements, because people are wondering, is generative AI a product? Or actually, is it broader than that? Is it a service, for example? And when we have to think about things in that way, a lot of lawyers refuse to actually write a terms of service agreement for generative AI. Because they say, how can you write a terms of use agreement for something that fundamentally has illimitable uses? I cannot parameterize how you will use it. I might say that this is responsible behavior, but we're not here in the business of writing contracts about behavior. We're in the business of writing contracts about how you should and should not use it. And so foundation models are so fundamental, and people have been building applications on top of it. Most commonly, people just build wrappers around them. So maybe if you're building a wrapper around it, you can say that this is your terms of use. But the problem is that OpenAI or any of these foundation model companies, they haven't negotiated the indemnification between people who are building applications on top of them and their responsibilities as the kind of base layer builders. And so that is where I would say retrofitting might not work. And so how do you deal with that? Air Canada most recently had that famous case, which I'm sure you've heard, is that their chatbot hallucinated a bereavement policy. And the courts had decided that actually it was the responsibility of Air Canada. But what's fascinating is that Air Canada brought up the argument that we should be trying these chatbots as separate legal entities. And so it's brought up the question again, do we need legal personhood for foundation models or generative AI? And it's not that we haven't, made artificial objects as persons before. Corporations are legal persons. And in many cases, different parts of nature may be considered as legal persons. So are we moving to a future where actually we need a new legal entity around foundation models? And so that, I think, is not retrofitting. That is actually new infrastructure that we have to build. So this is a really long-winded way of saying, I think, that at the moment right now, when I talk about technical interventions, we're really still only in the space of risk mitigation. There's a lot of work that's being done on, can you use kind of guardrails? And when I mean guardrails, it's like Python libraries that are used to kind of validate the outputs of these models to ensure that they're consistent with what you set out to do. You also have content moderation techniques that predate generative AI. For example, Llama 2 created Llama Guard, which is actually an input-output model. What that means is it's another LLM to check whether or not your inputs have adversarial attacks or prompt injections, or your prompt responses are unsafe. You can also validate that for your outputs. Those are all technical ways right now that we would advise actively for people building in this space to think about. But when it comes to governance, we're still struggling with the issues that I mentioned, is how do you retrofit and how do you build new architecture?
And one of the big problems or dilemmas with retrofitting or conceptualizing it is the rate of change.
Right.
It's unlike anything that we've previously seen. In our interview yesterday with the former president of Google Canada, he spoke about generally how we tend to overestimate things in the present and underestimate things in the future, but this might be the only case that he's aware of in which that's reversed.
Yeah.
So what kind of problems does that rapid rate of change pose to conceptualizing it or creating a new kind of corporate entity akin to the corporation?
Yeah, so I think that that's a great question. And one of the things I think about quite often is what went wrong necessarily with existing approaches around dealing with regulating AI. And it's not new, for sure, how people are thinking about regulation. The EU AI Act and what came out with the executive order, what was fascinating is that they decided to get a little bit more practical and a little bit more granular. And I think they learned from this idea that a top-down approach around building taxonomies of risk and harm was not necessarily the right way to go. And the issue is because the description and articulation of a risk and a harm is very disconnected from actually experiences of harm. And I always use this example, which is the partnership on AI has this thing called the AI database or AI incident database, where people are able to submit their reported experiences of harm. And sometimes these experiences are written as, for example, ChatGPT lies to me more in Chinese than in English. But the question here is what exactly is the harm experienced? Is it lying? Well, lying could be considered a hallucination from a technical standpoint. And from there, if you narrow it down, then, well, hallucination comes from maybe the perspective of the training data itself being more kind of tailored towards English-speaking texts or English-based texts as opposed to Chinese texts. And a lot of kind of what people are now discovering from that is if we're unable to exactly localize what actually is a harm, then articulating it won't be helpful because we can't draw the line of causation at all. And what's actually funny about that particular reported incident is that some of the South Korean community had a very similar experience, that they decided to use GPT-4 to look at some of their legal texts. They noticed that actually there was an insane rate or likelihood of hallucination, much worse than in any English setting. And what was fascinating about that is they were like, what if we just trained on our own legal texts? And it was monumentally better. And they said, well, actually, we're going to build models from the ground up. So now they're going to be building Korean-based legal text models or Korean large language models so that they can have them work more consistently. And, I come from a bit of a linguistic background, and so for me, I think language encodes our culture. It encodes our society, and a lot of the implicit knowledge we can't get rid of. And so even today, like one of the most recent academic papers that are out there, they still say that a lot of these models, their internal mental model is closer to English concepts than it is to any other language. And so there are efforts, for example, from companies like Cohere, which is a Canadian company, to have a strong multilingual model effort. And I think that is kind of where we're at the moment. So when it comes to regulation, when it comes to kind of how do we actually ensure AI trust and safety, we have to start actually at a very tactile, granular level. It might even make more sense to look at what are these incidents historically as opposed to go top down. Because at the end of the day, we don't have a shared common language for what is harm and what is risk, and I don't think we will.
You brought up a good point. In AI, fundamentally, data is destiny, right? So it's all about what the models are training on. And we'll dive into kind of all the IP issues that have been going on with data, but one thing that's come up and is starting to emerge as a technology is explainable AI, which will hopefully maybe uncode a lot of the black box and make it more transparent for us to understand the why and how models are making the decisions they are. I'm curious kind of if you've looked into explainable AI and its implications, I think, for the law, and it really relates to what you're talking.
Yeah, so I mean, that's a fascinating question because I personally am no expert in explainable AI.
That's crazy.
But one thing that I would say is in speaking with folks that come from explainable AI backgrounds, they are actually at a loss themselves. And many of them come from traditional machine learning backgrounds, even in NLP, which is, a close predecessor of large language models. And they're scratching their heads because not only have we, I think in many ways amplified the black box, but what's also interesting is that there's suddenly this new, almost semi-politicized movement around what is open source and being able to reveal exactly the data that you've trained, exactly the weights and parameters on that. And all of that still doesn't boil down to the actual question of why do these models produce outputs the way that they do? And there are other techniques that are coming forward. For example, there's an emerging debate actually between, do we need to continuously increase our context window? So for example, Google Gemini went to 1 million in terms of their context window, which is far exceeding of even Claude's 200K from Anthropic. Or should we still rely on these existing techniques such as RAG, or retrieval augmented generation? And what's funny is that these context windows alongside RAG have comparable levels of accuracy, but they don't have comparable levels of consistency and relevance. And RAG actually performs better when it comes to consistency and relevancy. And so if we're brainstorming, how do we best leverage our large language models? How do we try to ensure that the models are much more explainable, so to speak? What we're really looking for here is, can we look for patterns of auditability? And I think if that's the case, then I would say that RAG is probably something that people are more interested in. But going back to context windows, if you're just looking for whether or not it can retrieve certain kernels of information quickly, and you don't care whether or not that answer is always reproducible, then context windows are the way to go, maybe. So from a legal perspective, we think about down to this level, at least in our center, because we deal with legal texts every day, and they're hundreds and hundreds of pages. And so having a big context window is certainly easy for us.
That's so interesting. And I guess in our first question, you mentioned that at CodeX, you guys also focus on the inverse, which is, how are we applying AI to law? And I'd love for you to shed some light on that. And I think, for example, comp law, I was reading a lot of your comp law stuff, things like turbo tags that are just enabling people, ordinary people, you said, something like 80% of the population doesn't really have access to legal professionals. So how are we increasing accessibility to law today? What are the implications of that for society, and what excites you most about it?
Yeah, so actually there's a lot of exciting development in this space. I might start with some of our projects that we currently do, and then I'll maybe transition into a little bit about the access to justice, because a lot of that work, much of that vibrancy is coming from our neighboring centers. So actually where we're seated just across is the office of Margaret Hagan, who's the executive director of the Legal Design Lab. She's partnering with Professor David Enstrom, who actually just signed with the LA Superior Court to introduce generative AI into the courts.
Wow.
And so these are one of those ways in which you're starting to see, wow, even judges are tuning in to what could possibly offer with all of these technologies. But going back to kind of some of our projects, one of the biggest questions that we're currently faced with, actually, and many lawyers actually ask us, is how do you envision the partner in 20 years? Is our law school equipping our students sufficiently so that when they go on the job market, we are able to cultivate their talent? And in short, the answer is currently no. We don't know what's coming. And so a lot of the work that we've been trying to do is partner with law firms to build legal training tools. And some of these include contract negotiation simulations, for example. And how I describe this is, fighter pilots often do pilot simulations and go through a number of, example situations, and you navigate them before you even hop into a plane. A lot of law students, they come from, the very theoretical, bordering philosophical, legal space into practice immediately. That gap is monumental. And sometimes they are disillusioned by the grunt work that they experience and what that actually, where that came from. How do I deal with like all these interesting analytical skills that I got from, the sexy contract and tort cases that I was wrestling with in law school. And what we're trying to do is, when you have to go into a contract negotiation, we don't want it to be a baptism by fire. We want you to ease in. And so we're actually working with partners from M&A law firms of over 20 to 40 years of experience. They're giving us their kernels of wisdom to basically showcase, okay, if you have this certain factual scenario and this type of client, how do you ask the right questions so that you can get the best deal possible for the buyer or the seller? And so they have all the right toolkits. We're building different levels so it can go from junior associate to senior associate to partner level. So that's kind of the things that we're working on from that side. The other thing that we're working on is we're trying to kind of mirror some of the mentorship that already exists in law firms. So when you go in as a first-year associate, typically you're paired off with a partner, maybe a senior associate, depending on how big the law firm is. And all of these lawyers, so much of it is experiential knowledge. And it's a lot of this implicit understanding of the law and the client and industry kind of environment. But it's hard to articulate. If you ever ask your mentor, like, give me those kernels of wisdom, give me that advice, sometimes it's impossible for them to even know where to start. And only when you get down to like a precise example, they'll be like, well, I did this because of this and this. And so we're actually building a tool which could compare how you spot legal issues. And we're trying to draw out specific personalities of partners. So that say, I'm paired with Max. Max is my partner and he does things a certain way. I can see in advance why you would identify these issues in a contract. And then I'm like, okay, I'm going to mark up the contract as if, Max would be doing it.
Right.
But for some reason, I consistently miss this particular issue. I can't spot that issue, and I don't know why. So the next mentorship meeting you have, you'll be like, Max, I'm struggling with this. Why is that the case? And so your mentorship meetings, they're very, very short. They're now extremely targeted, and you're optimized to be more successful as a lawyer. Take differently, like Annabelle has a different style than Max, and I'm going into litigation. I might be dealing with a client that Annabelle has experience with. Can I then almost preview how Annabelle would have identified those issues? Then even though I'm being mentored by Max and I typically understand Max's style, I can get a look in advance in how Annabelle's going to deal with it. And so that's the type of tool that we want to build, and we want to keep pushing forward so that law students, young lawyers, have everything at their disposal.
This is fascinating. I mean, those sound like two really incredible initiatives, honing AI, similar parallels to the general educational space. And Saul Kahn talks extensively about the notion of giving every student a personal tutor, which seems to be something 5-10 years away. But going from the theoretical to the practical, lawyers are established, and some will likely be averse to change. In a lot of the talks that you've done so far to lawyers, you've begun with very simple demonstrations of what AI models like ChatGPT can do in very particular settings. It kind of illustrates that there are some in the legal community that aren't really aware of the monumental shift that might occur within the next 10 years. Have you encountered any frictions in thus far in convincing established lawyers about the utility of these technologies? Is there reluctance? Is there fear?
Yeah, that is a fantastic question, and I have to answer this with yes and no again.
Right. Yeah, the lawyer's response.
Yes, I have encountered it, but really the position there is we don't want to see generative AI for our end product uses. And what that means is they're afraid of using these tools to actually deal with client products. And, I don't blame them. But the problem in that particular space is if we don't give enough training, I think it boils down actually to training, is that there's a lack of familiarity with these tools. Just today I was on a call with someone that, a lot of these lawyers have never even opened ChatGPT, which to me is shocking, probably because I live in a particular bubble. And so for them, the fear becomes hypothetical. I don't think it's necessarily this idea of, oh, these tools are going to replace us. I think it is like genuinely a deep need for lawyers to have this level of perfectionism, to make sure that their clients are best served. And also ongoing news about how ChatGPT is hallucinating legal cases. And these hallucinations, I think, are kind of misleading. Because actually, a lot of the legal AI products that are out there, they either use RAG so that they ensure their responses are cabined to a particular database. The other side of it is that ChatGPT Plus, or even at the enterprise level, has certain levels of security and measures already in place that are far different from ChatGPT free version. GPT 3.5 is incredibly volatile. It's being updated every single day. And so to rely on a product that's experimental, it's user beware, basically.
Yeah.
Right.
And so when lawyers, bring up this fear and anxiety, honestly, it boils down to just open up the tool and use it. And if you're willing to dole out $20, then you might see even a marked difference between GPT 3.5 and GPT 4. And I think that some of the papers that have been out there, they created almost these unclear benchmarks about all the ways in which these tools are hallucinating facts. The problem is that they not once mentioned fine-tuning, and they not once mentioned RAG. And to me, that is a huge fault in empirical rigor in terms of those studies. And that's something that we need to work on as an academic community to say, yes, hallucinations exist, but what are those remedial actions? The second thing is, do we really need to be using these tools when fundamentally accuracy is supreme here? If accuracy is something that is really important, I would default to something like computational law or using good old-fashioned AI, formal methods, symbolic AI. That is sufficiently robust, it's reproducible, and it's highly accurate. And so I would say a deeper question here is actually, how much do we really understand about our own profession and what we've been doing in our existing practices? If you're relying on technologists know full well the limitations and the extent of use of their products. But lawyers don't necessarily know the full extent of their own practice. And so as we think about this and as we're faced head on with all of this technology, ask ourselves what types of tasks actually rely on consistency, accuracy, reproducibility, and then ask what other parts of our profession that are advisory, creative, highly, argumentative, all of those things, that brainstorming, exploratory element, large language models, that's the goal there.
Yeah.
So to me, I think the more we understand our own profession, our own experiences, and our own expertise, the better we'll be able to leverage these tools.
That's so exciting, and I think that's even something that everyone can understand, because I think that's a big issue right now because of the hype with Gen AI and LLMs. People are like, this is AI holistically, this is the only tool of AI, so they don't realize you can compartmentalize kind of, like Gen AI, I think we've learned to embrace these hallucinations and be like, oh, okay, suddenly AI is good at creative tasks, something we 5 years ago never would have thought, but let's embrace that. Let's think about which functions in our daily lives require that. So super interesting. I think you bring up a really good point, which hasn't been talked about a lot in other podcasts I've listened to, which is RAG. I'd love for you to explain to our listeners a bit more about RAG, but also maybe explain to them the significance of RAG, when it's used, what it is, and maybe if you can speak on fine-tuning a bit.
Yeah, so these are two techniques that actually are now commonly used for dealing with large language models, and also, with traditional machine learning and NLP as well. The notion of RAG specifically is retrieval augmented generation. What it really is that you're basically pointing the model to a specific set of data, and you're saying, don't look anything outside of this.
Okay.
Just point yourselves to this particular direction. You're only retrieving from this section. Right now, the models without that, it's going to look everywhere and anything for it. Here you're saying only here and that's it. If you don't know, then it'll come back with a response. It's not within the database, so I don't know. And I think that enables the models to be a little bit more consistent with their responses, because you're saying this is all that you can use. And I think it's the same way with humans. If you tell them, like, you can only look at this book and nothing else, your answers are going to be cabined to that book. So that's the same thing, I think, in this particular case. With fine-tuning, it's a little bit different. What it is that you're adding almost a layer of training that is specialized, a specialized data set over it. And so when we say you're fine-tuning a model, what you're doing is that you're basically exposing that particular model to a lot more specialized legal training. Again, to use humans as an example or analogy, it's like taking them to law school effectively and getting them to be more exposed with that particular type of knowledge.
Yeah.
So one thing that I want to go back to in your previous response just quickly is that notion of unrigorous science ringing alarm bells that needn't be rung. That's not necessarily something unique to law. We see it all across all across coverage of Gen AI and these new technologies. But within that kind of inundation of fears that are unwarranted, there also are fears that are warranted. What are some of the biggest ones, in your opinion, that we should be concerned about, that the scientific community or larger are raising?
Yeah, that is a great question, because, for a while there was a whirlwind of conversation around AGI, existential risk, and all of that. And to me, I think at the end of the day, the risks that we need to be most aware of are the ones that are right in front of us. And a lot of people might be referring to questions of, say, fairness and bias. And earlier today, I talked about almost an inverse shocking example, which is Google Gemini, that came out with saying, all across social media, you can't produce an image of a Caucasian man. And you can't, and the worst part is that it's sort of like rewriting history almost. It's bringing in characters that don't actually exist, or they were in a social stratification that was just not true.
Yeah.
And I think the problem with that is, and this level of overcorrection, is this reality that we're afraid to face our own truths about society.
Yeah.
I think the problem with using content moderation techniques for this era of large language models is basically thinking that we can erase bias, and that we can, by erasing bias, we get to a level of fairness. And I think that is honestly, to me, one of the bigger risks, is that we're unable to acknowledge that mistakes were made in the past, and that we just simply see things very, honestly black and white, like, this is what should be considered, culturally acceptable. This is not culturally acceptable. But it misses all of the grays and nuances in between. And I think if we start to acknowledge that these models are just basically playing out behaviors that we've done ourselves in the past, that's really what we need to be tackling. And one thing to put differently is, a lot of people don't understand the comparative advantage of these models or machines with humans. We always want the models to be more like humans. And I think that is a very weird thing. Because even in a team, what makes a successful team, a great collaboration, is that we all have different strengths and all understand each other's weaknesses to reconcile them. In the same way, our tools should be the same. These models are great at high velocity, high volume processing of information. Humans, a lot of us can be great at doing so. We think very dynamically, but we reach our certain limits in terms of memorization or how much information we can intake. Other angles of it is that even if you have photographic memory, we don't have perfect retrieval either. And so how do you actually negotiate where humans continue to take hold of certain tasks and where to interject machines? I think we've been very shallow in terms of how we've tried to divide that. We're saying all menial work, all low-level tasks, but that is incredibly vague.
Yeah.
We say things like, oh, these models can do what interns do. Have you consistently created a framework around what you give your interns? Why is it that some interns have better experiences than others? In the same way, we don't think thoroughly, again, about how we've always done our workflows and exactly where we can augment. And I hate when people say like, these tools are augmenting or are co-pilots. We never had co-pilots in our organic setting. So to use this term, it means that we're kind of just injecting the model as opposed to integrating it. And I think that is something that this year, as we enter into maturity of using generative AI, that's what we should be thinking about.
That's so interesting. And I think one thing you brought up earlier in your response was how we're kind of, these biases that are coming up and whatnot. It's almost like what we're playing out, what we've done in the past, right? Because again, that whole notion of data is destiny. Actually, just recently, my boss from the summer, who was huge in the AI space, he actually just wrote an article, an op-ed in, what was it, Times? Or
New York Times.
New York Times, yeah, about kind of how AI... Everyone's worried about AI coming for the future, but it also can come for the past. For example, these hallucinations, it can, or Gen AI can compose a great story about how, let's say, the Armenian genocide never really happened. And I think but we've saw an emergence in watermarking, like the tools are existing, but I think the application of the tools are still a bit fuzzy. Just recently, there's a deep fake of really explicit photos of Taylor Swift that got like 47 million views. So how, in your opinion, are we going to get to a point where we can effectively apply these watermarking tools to ensure that, we are mitigating the risks associated with these terrible things that might come out of models?
So I will say that I actually do not know as much about data watermarking or data provenance to really confidently say that much about this particular innovation. But what I will say is that there are a lot of efforts right now, especially coming from MIT, on questions about data provenance and creating a protocol around that. And there's a lot of various protocols that have emerged, as I mentioned. There's emerging blockchain efforts on this. How do you leverage existing sort of zero trust technology to kind of help with this type of assurance around validity? One thing that I have been thinking about a lot is, as I looked into some of the guardrails that are being out there, especially Llama Guard, for example, which is actually a fine-tuned Llama 2 model that's an input and output model. What that means is that they've not only defined broadly what is safe and unsafe, what they've done actually is that they train their model on some of Anthropic's data set on what is determined to be within their constitution. And I'm not sure if you're familiar with this, but Anthropic came out with something called constitutional AI, which they tried to align their model with a constitution. And this constitution was loosely based off of UN's, human rights principles and things like that. There are some areas that are problematic, I'd say. One thing being they didn't really consult in advance certain stakeholders. It is their own internal constitution, so to speak. They came up with a follow-up paper to showcase that actually the distance from their own constitution to the people's constitution, there was a gap. But I will say that sometimes actually learning from our mistakes, maybe even using incidences that came out from Cambridge Analytica, all that data, or even looking into all incidents of social media misinformation and disinformation. Can we use these quote unquote bad data sets to help build tools that can better monitor at a continuous level, and to be able to sharply say that this is actually an incident, or better verify? Because I think people think that humans have the capability to constantly be able to do that verification work. But as I said, a lot of these large language models are actually incredibly great at processing high volumes of information. So maybe they could be the initial first triaging layer behind what is a real image or not, what is a safe image or not. And then you can redirect to a human to then do that final quality assurance and final approval. And we're starting to explore some of that actually from the perspective of supervisory AI agents. They're essentially, almost like in an analog version,
medical triaging diagnosis tools like Babylon Health that you can kind of input your symptoms, not WebMD, just to contextualize, but like these sophisticated medical diagnosis tools that leverage traditional AI to say, okay, it's likely this, maybe we need to redirect to this type of doctor versus not. Or, even more analog, the role of nurse practitioners helping to alleviate some of that load on doctors that are trying to diagnose very quickly. We see basically a role of AI agents, otherwise known as AI as a service or an autonomous worker, that can very early on look at a set of criteria that has been defined from historical information around what is misinformation, what is disinformation, and experiential knowledge of that. So actual data sets that have been leaked or actual reported incidents of harm related to misinformation, aggregate all this information to communicate to a large language model, maybe fine-tune a large language model to analyze in advance. Yes, this might be an incident of misinformation. No, this is not, we're good. Or yes, it is, redirect to a human to confirm, or redirect to a privacy lawyer or any other specialist to look, and then kind of confirm. And that's the role that we're seeing actually with these regulatory AI agents that are emerging. And so kind of, this is a bit of a total tangent from your initial question of data watermarking. But I think the point here is that beyond just looking at the technology itself as a singular type of thing, we can actually use this technology for multiple things. When we say something like who guards the guards, well, it's like AI guarding the AI, and then human overlooking all of it.
Right.
And so that's something that we've been starting to brainstorm or think about.
Something really interesting that I think comes up in that last answer is this notion of democratization that we spoke of earlier. AI being used in different areas and different disciplines to help problems, to provide governance, to do all these different things. Have you seen over the course of the last 5 years any order in which AI is applied or seen? How can we assure that disciplines have relatively democratized access to AI tools? How can we make this as largely accessible a technology as possible?
That is a great question. So a lot of people actually have historically looked at AI from healthcare and a medical perspective. Naturally, it's because I think that sciences, they all communicate with each other quite quickly. People in the, at least academic sense, they usually are cross-listed on the faculty very easily and very fluidly. We have like MD, PhDs and things like that. So, and what's also interesting is actually doctors have a specific duty to stay abreast of new technology. That is within a duty known as duty of competence. Lawyers, similarly, have a duty of competence. But what's different is that technology is never discussed in that duty, meaning you can be competent in your knowledge of the law, you can be competent with existing tools, but you have no duty to understand what could help you going forward. So analogize it this way. If a doctor said to you, well, I'm using, this stethoscope technology from the 90s, it's a standard of care. I've done it for years. You're going to be fine. You would freak out. And so I think actually your question about permutation into certain disciplines, the uptake or natural interest in AI or use of AI and how you can best leverage it, it really actually boils down to me some of the existing legal architecture and regulatory architecture that's already existed. And so here I can say AI in healthcare is probably one of the most advanced fields. Legal should be, but we are barred by the fact that something as simple as we don't need to care about technology is enough to preclude many lawyers from thinking about it.
That's so interesting. And I guess here at CodeX, you guys are really transforming that landscape. Are you optimistic? It's a tough customer, I guess. Lawyers are tough clients to kind of deal with change from the technology aspect. Are you optimistic? And what's worked so far, I guess, to help push the needle on that front?
So I'm very optimistic.
Yeah, I guess you
the reason
dedicated
I
your
am
life to it. So
yeah.
I hope so.
I am actually for a peculiar reason. And that is because lawyers got shocked into awareness about generative AI, not because, they necessarily care a lot about technology or the fear of replacement. It's because it impacted their favorite tool in the world, which is Microsoft Word. Because Microsoft had this incredible partnership with OpenAI, still do, Microsoft Copilot became very real for them. Every single law firm relies on subscriptions, the highest level of subscription to Office 365. The foundational use of Microsoft, that's what got to lawyers, because they're like, not only am I given the choice of whether or not I need to use this technology. So in the past, you had tons of legal tech vendors doing really fascinating things to make contracts more simple and easy to navigate. They didn't care because I have Microsoft Word. Now Microsoft Word, if you activate Copilot with a click of a button, you are impacted in ways that you might not understand. That's what scares the lawyers. And that shock is now why I think many lawyers are saying, I need to know a little bit more about this. And so it's funny because we always think, you know, there's all this resistance externally, but it comes down to, is there a threat to my existing status quo? And the status quo is not actually necessarily always at a macro level. It just comes down to, wait, I have to be forced to behave differently with something I already knew. And I knew this for a long time in the sense of some of my closest friends, they work at, you know, these incredible big law firms. And when I asked her about all this technology, she was really excited about it. And I was like, well, like, would you consider using it? And she says, well, I like my folders and I like how I organize my folders. And I was like, well, that is more than enough to tell me exactly the state of the art for most lawyers. But when you threaten the tool that they use every day, every minute, all the time, that's how you penetrate the market.
And what has this timeline looked like so far? So when was that initial kind of shock? And to what degree have lawyers been open to change since? Is that compounding? Is it exponential?
I think it's hard to say when exactly generative AI really took hold. It could be because of the New York Times case. That could be a marker. It could be when Microsoft officially announced the big splash around how they work with OpenAI. But I think a lot of it happened as more incumbents felt the pressure to integrate generative AI. And the legal tech landscape is quite interesting. People underestimate actually just how powerful these incumbents are. Thomson Reuters and LexisNexis, they have a total foothold on a lot of legal technology. And a lot of these mavericks that have been circulating in this space for a while, they started to get slowly vacuumed up by these big, incumbents. And so you think that a lot of the market with these really interesting new startups, that the space is going to be flooded with all of this new innovation. Well, this innovation gets really exciting, then whoop, there goes Thomson Reuters purchasing it, or LexisNexis purchases it. Actually, one of the companies that early days was founded actually at CodeX. They had one of the most incredible acquisitions by Thomson Reuters. And it's because they were the first to actually partner with OpenAI. And they created this product called CoCounsel. And Case Text, though, was around for 10 years before this happened. So it's hard to really say again, exactly that moment of spark, but there's a lot of signaling power that exists in the legal tech market, and that's largely because it's driven by incumbents. And I think no matter how we put it, that's going to continuously be the reason why lawyers care.
That's so interesting, and I've been dying to ask you this question about kind of it's going back to a lot of the data questions we were talking about, but maybe a bit more technical. But you know, in the data world, I think right now we're seeing a lot more restrictions or like lawsuits coming out against OpenAI from like there was like a class action lawsuit, right, and other lawsuits about people getting really mad at like in New York Times actually is threatening to sue OpenAI for using their data to train their models, but they claim they're using just data that's publicly available. Where do you see that battle going between kind of the legal fight between other people being really uncomfortable with these bigger models using their data to train, and what is your take on all of that action and that conflict right now?
So I feel like I've been contextualizing a lot of my answers, but it's necessary when you're in a legal space.
Yeah.
But I am not a copyright or IP expert.
Oh, okay, fair.
But actually, a couple of our professors that work here do represent the folks that are involved in the cases that you've mentioned. But I think a lot of the standpoint right now hinges around this notion of fair use, which is not really well defined. And a lot of people, if we're thinking about retrofitting architecture, that is a big one. Because in the past, this analogy that we put out there is if someone is opening a book and reading it, learning from it, and then doing something from it, that's considered fair use.
Yeah.
But why is it different when a machine does it? Is it because there is some sort of commercial layer involved? So it's actually like a kind of capitalist business reason or trade secret reason, so to speak, that has come out of it. But I think going back to the human side versus the machine side, to me it boils down to scalability. For humans, even if you're able to learn, even if you're a savant, so to speak, and you like go through like troves and troves of books and learn from all of this and are able to kind of then draft beautiful pieces, there is a limit.
Yeah.
With these models, there is no limit. So is this relative strength of the model, that point is what tips over the scale of fair use? I'm not sure. And so to me, that's, I think, what it's boiling down to. There's a lot of specifics within copyright that I am not at any liberty to be able to kind of communicate nearly as well as most of the experts here. But I think that that's really kind of the hinging point is, do we need to redefine actually copyright altogether? And more specific to that is, what is it exactly about the training of these models that is so concerning? Is it that it's reproducing an exact likeness, that like plagiarism kind of notion, or this stealing from the style? So I'm sure many of you have heard of the song, which was like a Drake Weeknd collaboration, which was actually not real.
Yeah.
To me, that is actually kind of creative. It's almost like, oh, it's gonna like spark new like types
it's like
of
EDM
genres.
in the house when like DJs are mixing.
Or OpenAI released Sora, for example, and there's like, and to me, the most exciting part of that is we were able to dream up, like these interesting like dolphins swimming in downtown New York City, or like being able to break or go into magic realism. I think that is like activating a new sense of creativity. But is our use of it that we simply just want to reproduce all of the Harry Potter books and serve it on a plate? I'm not sure that there are many people that are doing that. And that's what is a little bit confusing to me. The other side that people fear is potentially damaging is just from a, say, fashion perspective or a young, like kind of new emerging artist, is that you're going to be just eclipsed by the ability of these machines to produce at such magnitude. Is that you just become a dot in the scale of training data, whereas you were trying to define your own style. Like, it's very well to say like, oh, I'm building like a video out of Wes Anderson's style, something that's already really well known and positioned. You're not really taking away from it. People understand that it's some sort of like parody or satire. But if you're a new artist and that Sora or any other text to image generation is producing to that level of likeness, then you're probably going to feel like your work is not going to be valued very well. You're not going to be able to define your individuality. So that's, I think, the delicate line, really.
Right.
And it's interesting because that actually was brought up in a Bill Gates, Sam Altman interview, which is like, it's almost like we're at a point where, maybe not today presently, where AIs are, almost redefining human purpose in a sense because of that capability aspect. Because, I think Bill gave the example of, his thing is working on malaria. And like, that's where he gets all his satisfaction and purpose in life today. And, what if one day, like the AI, he can, pop into Chat GPT or whatever, being like, hey, can you like help me with this malaria problem? And then they're like, yeah, Bill, actually I can do it way quicker than you. Go play pickleball, or like go on a break. Yeah. So I think that capability, like defining where that capability kind of turning point is with human purpose is so critical. Not only for, for us to understand like, what kind of problems we want to lean into, where we want to work, but even you can think of it from the policy perspective in terms of, when are the capabilities just too great to the point of like maybe keeping things open source is just not even safe anymore. So there's so many implications to really defining that capability aspect. And I think you mentioned something really interesting. It's like, yeah, that's kind of like a crazy thing to think about, but the best way to engage with all of these like profound rapid rates of change is just be present with it, know where it is right now. But I'm curious if you have anything else to add to that whole little spiel I just gave. And
a good example I think about is my parents use ChatGPT.
Awesome.
And they use it because they are curious by why I spend so many hours doing these types of things. And so I said, I'll pay for your subscription, go do it. And I share a lot of this information with them where I was like, I want you to test out the different capabilities. And one thing that they were thinking about was maybe I'll use GPT-4 Vision. Oh, cool. And I had given them an example of, that you can like take a picture of this particular dish that you enjoyed, and then it will reason with you the ingredients that are in it. So you might want to make it in the future. So my mom decided to take a picture of the fridge and asked GPT-4 Vision, can you draft me a recipe of what I could make for dinner based on what's in my fridge?
Wow.
And it came up with, a couple of good recipes. But one thing that my mom said that really struck me was, well, they had a really weird pairing with sriracha and some other sauce that we had in the fridge. And I thought, why does that come off kind of weird to me? And what I realized is the model has difficulty reasoning with different ethnic ingredients. Mm-hmm. It could do very well, like when my mom asked something like, give me a risotto recipe or give me a pasta recipe. But when it understood down to like very specific types of ingredients that are used in different cultures, it had its limitations. And so we would have never been able to unpack that as a potential like hurdle with GPT-4 Vision had my mom not actually just tried it out. And so that's why I always say like, go and experiment, because experimentation is actually one of the reasons how you can uncover some of these.
Right.
And like going back to when I talked about the top-down approach and why it's problematic, you could never understand things from a high level, abstract level, because you have an eye to nowhere. Mm-hmm. You want to understand what are those actual grounded experiences and interpretations of the uses of technology.
I think that's such a fantastically interesting notion, this idea that ChatGPT and these other AI technologies fundamentally change our lives, but more than that, change our relation to concepts as fundamental as time and space, akin to other previous technological developments, but at a much larger and more dramatic scale. So it's very, very difficult to take existing standards of, say, artistic creativity or recipes for that matter, or other things, and to generalize them into unknown aspects in 5 years for which we have no real foresight at the moment. That's one of the biggest sources of anxiety for people going forwards. And although we can sit here as people that have researched and engaged with this technology to a great degree there's also a lot of skepticism from those who haven't really taken the time, who may not be able to afford to experiment with them as much as we can. What is your advice for getting those people as excited about this new uncharted future as we are? As optimistic about the dynamism, the power, the transformative capability of artificial intelligence?
That's a great question. So I feel like part of the messaging behind the open source movement is that they wanted to build tools that are widely accessible, because you can just basically open up Hugging Face or some other platform and log into it and use it. I think in the past there was questions about the digital divide being, some places, and there were even what they call Wi-Fi deserts, where you saw students that during COVID having to hover by McDonald's, even though McDonald's was closed in the facility, they had to be in the parking lots to get access to internet. I think a new layer of this digital divide comes with generative AI divide. The stratification around like the powerful tools versus the basic entry-level tools. And I think the open source movement is trying to contribute to leveling some of that. And, for example, Google, although they released Gemini, they also released Gemma, which was the open source version of it. The difficulty with the open source movement, I think, is the fact that they like to build things at the model level for you to fine tune and build with the model. You don't have that interface level, which is what Anthropic or some of these and OpenAI, these like proprietary models do very well, or even Google's Gemini. And so I think going forward, what we really need, at least one of the projects that we've been doing over at our center, is we wanted to build using something comparable to GPT-4, a kind of interactive tool so that anyone could use it to engage with legal text, and not just having to use purchase, say, Thomson Reuters tool or something like that. I think what needs to happen is that at some point there should be, to me, some level of commitment. Maybe this will come from governing bodies or whatnot, to actually understand how do we wrestle with this new digital divide. I think that rather than just determining whether or not these tools are safe or unsafe, if you realize just how ubiquitous use is going to be, one of the things that you should be thinking about as a regulator is how do you tackle equalizing and democratizing this technology? And it's not that this technology is not widely available. It's just that even the versions that are free, people haven't gone to the level of understanding the difference in their power. And I think that that is going to be a major issue. The other thing is going to be about compute power. There's already a massive issue around shortage of GPUs, or certain companies having possession of a lot of GPUs over others. The other thing is about semiconductors, the chips. That is becoming another bit of a power struggle, where you have certain companies monopolizing how the chip market is transforming. I mean, Sam is thinking of requiring 7 trillion, 8 trillion. I'm not even sure I can't even conceptualize how much money that is. So these are all these small power relationships that they're not actually very different from historically how other technology has played out, but it's taking new forms, and these are things that regulators should be paying attention to. When we talk about impending risks, these are what we need to care about, not kind of vague existential type, futuristic. It's what are the shifts and transformations in power relationships that are played out at every level of the technology stack.
Yeah, and it's so interesting when you bring up that balance of open source, closed source, and it's kind of like the new thing is emerging right now, I think, because right now there is such a, because we talked about the difference in these foundational models, they have all the power, and I think as a developer, there's even a debate as to how open source are these claimed open source models, really, right? So I'm curious for you is what is the path forward to defining the line between open source, closed source? Do you think we'll be able to, is there anything we can learn kind of from, again, the things what we saw with Meta and, how they came to rise up, got a lot of power, and then, we try to toss antitrust lawsuits at them, but they seem to be really good at dodging them. Anything we can learn from that? And then also, how do we define the line of open source, closed source, and are you optimistic?
Yeah, that's a great question. Maybe I'll think about, so In terms of antitrust, I would say that actually there's a much better scholar position to talk about this. Professor Thibaut Schreppel, he's not only one of our affiliated faculty at CodeX, but he's also with Amsterdam and also occasionally teaches at Sciences Po. He does a lot of work in computational antitrust.
Yeah.
Is detecting, using computational tools to detect potential collusion and things like that. I think you're certainly right that technology has this power, and it's almost like a silent power to be able to centralize a lot of their control over certain things. And, almost the idea that these companies that are, building the chips or optimizing these chips or getting the GPUs, that's all been relatively under the radar. And that's intentional because a lot of people don't have a deep understanding necessarily of technology and what it takes to actually power generative AI. You only see things at the model level. So you're pointing to the OpenAI and you're pointing to Anthropic and things like that. But what's going to be even more interesting is the consortium that will form. Google is partnering with Hugging Face, which is a known open source platform. But what does that relationship necessarily mean? And actually right now, the FTC, they are actually tracking some of this for real. And
Awesome.
they're looking at actually what are the types of partnerships and collaborations that are existing between these different ecosystems that seem disparate but are coming together. And so I think that is definitely a space to watch. And it's something that's definitely top of mind. And the kind of front runner or big spokesperson behind open source, which is Hugging Face, we are seeing lots of models from Mistral, even Meta's Llama 2. There are questions around what is this line of open source, right? Because with Llama 2, yes, it is open source, but open source to a certain extent. Meaning once you get to a certain level of almost commercial viability with a certain number of clients, Meta owns a bit of it. And when I say a bit, could be quite a bit. So I think if we're thinking about going back again to legal frameworks, do we actually need to formalize the definition on open source so that we actually transparently as a community say, yes, this is open source or no, this is not. And sometimes open source, people even came to think that it was related to whether or not you have total ownership of the data. That's actually starting to become not necessarily true. A lot of these open source companies actually still retain your data, whether or not it's as serious or as kind of problematic from a privacy standpoint as, known closed companies such as, OpenAI or Anthropic. I think that definition tends to mostly focus again on the model itself, not knowing the specific weights, not knowing the training data. That's really how people have historically defined closed. But even retention of data, should that be added to the definition of open source versus closed? I think you're right, exactly, Annabelle, that we need to negotiate this.
Yeah.
And the fact that more and more of this is coming up, we're actually getting specific about what we want and expect from our technology, which was not the case last year. And so actually I think all of this is a good thing. People think, there's more problems, we're just opening Pandora's box. Good, let it all out.
Yeah.
And let's actually reason and negotiate it.
Oh, this has been such a fantastic, such a fascinating interview. I wish that we could keep going, but we're approaching time. Just one last question, because I don't want the conversation to stop here. Do you have any recommended resources, whether books, podcasts, anything else that our listeners, our viewers might be able to engage with to further these conversations, to go into their own rabbit holes, to explore the fascinating new technologies that encompass this revolution?
Yeah, it's funny. I always get asked this question and I'm always stuck because the rate at which the technology is changing and all of these issues are evolving is happening so quickly. I will say one thing is that I always tell people this is a great opportunity to understand yourself better. And that's what I had mentioned earlier. Take this time to really take stake of what you think you know about the work that you do and really start to organize that. Because as this technology approaches you, if you're unprepared with understanding yourself, you are just unprepared, period. Second, I think more of a fun or quirky one is although I'm not a huge fan of Twitter or now X, that's a great place where a lot of developers are talking.
Yeah.
And so usually some of those interesting developments or first sign or symptoms of them, that actually starts at X or Twitter.
Wow.
And so even scrolling through, sometimes you might start to unlock a couple of interesting kernels. So I would say stay tuned on X. I'm not endorsing it, so to speak, but that's one that sometimes it's just a good almost like pulse on the market.
Yeah, no, I've definitely had my fair share of rabbit holes on X, and I'd continue saying log out, or else I will stay in this vacuum forever. No, this was such a pleasure. I could have keep talking with you about the open source, closed source nuance for hours, but I'm curious, is there anything else that you think we may have missed that you want to share with everyone?
I mean, that's all for now, I guess.
Well, I guess there's, are you going to say
I'm
something?
saying, if you want to learn more about our center, or, if you have any more questions, you can reach out to me. I'm happy to always answer.
Well, Megan, thank you for joining us on our AI Odyssey.